And welcome to our live podcast. This is Dr. Olu Asekun here. We do this podcast every Wednesday. Do I need this?
Yeah. You can keep talking.
We do it every Wednesday, 12 p.m. Central Standard Time, 1 p.m. Eastern Time, 10 a.m. Pacific Time, and currently 6 p.m. Nigerian Time. So, if you are joining us for the first time, remember to call your family, friends, colleagues at work. We do this every Wednesday, and it is we provide very valuable information. So today, we are dealing with the President Biden executive order as it affects parole in place, PIP. So the parole in place is currently on. It is now available. So if you are the spouse of a U.S. citizen or parent of a U.S. citizen, or no, not parent, child of a U.S. citizen, or stepchild, you may be eligible. So it is available right now. USCIS has released the form to be completed to start this process. Um, that is the topic we are discussing today. So you may be eligible for PIP. That is a parole in place in order for you to be able to adjust. It is only applicable for people who enter the United States without inspection. That is, you didn't come with a visa and you have lived here for not less than 10 years, and you are married to a U.S. citizen, or you are the child or stepchild of a U.S. citizen. So those are the only people that it's applicable to. So if you meet this requirement, you may be eligible. Like I said, the forms have now been released. That process is going to be completed through Form I-131F. I think that's the form, yes. I-131F. So, and it can only be filed online. So if you are eligible, this is the time to apply. Now, that is the topic we are discussing today. Unfortunately, I will not be able to complete this program today. Some of my team members will join as I have a hearing. In fact, I have multiple hearings at the immigration court this afternoon. So I will be leaving probably within the next 10 minutes for the immigration court. But in the meantime, that is the topic we are discussing today. So if you have questions, so start sending in your questions. We are discussing the parole in place. Generally, the U.S. immigration law states that if anyone does not enter the United States, if you did not enter the United States with a visa, if you are not admitted into the United States or paroled into the United States, you are not eligible for adjustment of status. That means it doesn't matter whether you are married to a U.S. citizen or not. If you enter the United States without a visa and you are not admitted at the port of entry, you are not paroled into the United States, you cannot apply for green card in the United States. That is the law. However, that is what President Biden is trying to make easy for some set of people. Although the law says you cannot apply for adjustment of status except you are paroled or you enter with a visa, that parole is what the president is trying to provide for some people. This is not applicable to everybody. It is only for some people who meet that requirement. If you have been living in the United States for not less than 10 years, as of June, what is that date? As of June 17, 2024, if you have been living in the United States for not less than 10 years, and if you are married, if you are currently married to a United States citizen, or you are the child of a United States citizen, or stepchild, yeah, it covers both children and stepchildren of United States citizens. So you may be eligible to apply for parole in place. So what that does is that the parole in place will give you the opportunity to be paroled, in which case you can subsequently apply for adjustment of status. So that is what it means. Now, if the parole in place is granted, it is usually valid for 3 years, and you will have the opportunity to apply for adjustment of status, to apply for green card within that 3 years. So if your parole in place is granted today, so you have the opportunity to use it between today and the next 3 years. Whenever it is granted, you have 3 years to use it. So definitely, if your problem has been inability to apply for adjustment of status because of lack of legal entry, so if you are now paroled, I don't know why you will even wait 3 years to apply for adjustment. So it's an opportunity that is available right now, and that is the topic we are discussing today. How can I say if I have questions? I'm not able to. No, I'm not able to see my screen. Let's see. I don't know. Oh, I'm not able to see my screen.
I don't see any questions yet.
Okay. So it's just rolling. I don't see anything.
Where is it? No, okay.
Okay. Just let me know whenever you have questions, since I'm not able to see it yet. So if you meet this requirement, of course, you have the opportunity to apply for adjustment of status. So going back to the requirement of adjustment of status, parole in place does not waive the requirement of adjustment of status. The requirement of adjustment of status remain the same. So even if you are paroled, you still have to meet the requirement for adjustment of status. That means you still have to file a petition, or you still have to have a petition filed on your behalf or approved on your behalf. You still have to meet the requirement of adjustment by showing that you do not have disqualifying criminal record. You still have to meet the requirement of adjustment of status by showing that you are not inadmissible on health ground. You are not inadmissible on criminal ground. You are not inadmissible on misrepresentation or any other form of inadmissibility. So you still have to meet the requirement for adjustment of status. So the parole in place only solve one problem, and that problem is IWI, entry without inspection. That is the only problem that is resolved by the parole in place for those who are eligible. Also, under the president's executive action, for DACA recipients who have been here for not less than 10 years, who obtain a degree, a college degree from an American university, who meet the requirement of H-1B, they may also be able to apply for H-1B under the parole in place. Because, again, as already known, for employment-based application, every applicant applying for any employment-based application must show proof of legal status from the first day of entry until the date of the application. So that is what the parole in place is addressing for DACA recipient. So even if DACA recipient enter the United States without a visa, if you apply for and you are granted the parole in place, you will now be able to apply for employment-based petition, meaning you'll be able to apply for H-1B, and if you are lucky, your employer is willing to make it permanent, your employer can submit immigrant visa application on your behalf, and you can go through the difference between a legal application and a discretionary application is that for a legal application, the Congress has to pass a law, and that law has to be signed into law by the president. But in this case, the president and the Congress is not involved. This is a discretionary power of the United States president. He is using his discretionary power. So it's going to be, each application is going to be looked at on a case by case basis. It is not a blanket grant. For it to be a blanket grant, there has to be a law to that effect passed by the Congress. But in this case, it's going to be on a case by case basis. For example, two people can apply. The government can determine that one of them have terroristic tendencies. So they can use that to deny it because it is a discretionary thing. It is not a legal thing. You cannot go to court to challenge their decision if they decide not to give you. So that is what it means by being discretionary. And that is the reason, because it is a discretionary power of the president that is being exercised here. The next question: will this apply if I have a permanent bar? I don't think I understand that. I mean, from the word permanent, if somebody is statutorily barred, because permanent bar is usually statutory. So an executive order cannot override a statutory authority. That is one of the things I just explained in the discretionary issue. So when a Congress passed a law and that law is signed into law by the president, it becomes statutory. So the president cannot use the president cannot use a discretionary power to override a statutory authority, to override a law passed by the Congress. So if somebody is permanently barred, that is a statutory provision. So an executive order cannot override that. The next question. Well, I think I have to leave now. The team member will continue from this moment. It is already 12:16. I have multiple cases at the immigration court in Dallas, so I will have to be excused. So who is joining? Is it Kim? Okay. So thank you. Hope to see you next week, but continue with the program.
I need this. Okay. Oh, that is high. Am I too tall? Okay. Okay. Good afternoon. So, as the lawyer said, he does have court this afternoon, so he had to step out. But if you have joined us before, then you may recognize my face. My name is Kimberly. I am a paralegal here at the law office, and I will be continuing where the lawyer left off. So, as you mentioned, today we're talking about parole in place and keeping families together under President Biden's affirmative relief program. So, let me go back to the questions. Why isn't it coming out? Okay. So, how can I prove continuous residence? Okay, continuous residence can be proved in a couple of different ways. If you've been filing your taxes, then you can provide tax returns and W 2s. If you have been renting your place, then you can show that you have a lease agreement somewhere, or if there are different bills that are in your name. Anything that can show that you have been living here in the United States. A bank account, if you have a bank account and you have charges that have been happening here in the United States, anything along those lines can show that you have been physically here, because if you're making transactions through your bank or if you have a lease agreement, those things tend to mean that you are here physically present in the United States. So, those are some good ways to do that. How long will this PIP be available? Now, that's a very good question. Uh, Unfortunately, we don't know for certain. There is no timeline for this right now. And given that it is an executive order, meaning that President Biden is the one who, announced this, depending on how the election goes in November, could very well determine how long this is in place. Uh, because President Trump, he tried to do away with DACA before, so we can't be certain that this will stay. So, honestly, if you are eligible, I would go ahead and apply right away. It's been available since Monday. And as the lawyer said, it's exclusively online. So, because we don't know how long it's going to be in effect, go ahead and apply right now. I actually saw on Twitter, now this is not verified, it's just something that I saw on, sorry, X. I saw an attorney say that she had already gotten one approved. Now, that's really fast because it was yesterday that this was submitted. So I do believe that USCIS is serious. If you submit everything that is required for this application, then I believe that, USCIS will be doing their best to make sure that they adjudicate these in a timely manner. So, really, if you can, go ahead and apply. Now, saying that if you're eligible, go ahead and apply right away. That does not mean that you should rush when putting together your application. You need to make sure that you have everything that's required right when you file. I say this because there is no appeal and there's no motion to reopen for this type of application. Now you can file it again, but to save yourself some money, just go ahead and make sure that you have all of the requirements, that you are filing everything that you need so that you don't have to file this over again. So while I say, go ahead and apply as soon as possible, that does not mean rush through your application. Take the time to make sure that everything is correct, gather all of your documents, and then submit it. But do so while you can. The next question. My spouse is a permanent resident. Can he apply for naturalization first so I can qualify for parole in place? So, yes, as long as you were married on or before June 17th, 2024, then yes, because permanent residents don't have these same benefits. You cannot apply as a spouse of a permanent resident. So, yes, go ahead and have your spouse naturalize. They are adjudicating naturalizations pretty fast right now. So, I would say get your application in and make sure that he gets naturalized as soon as possible. And then go ahead and submit your own application for the parole in place. Question received via text. I entered illegally 4 times and I have everything required for PIP. Will the multiple entries affect me? So, this kind of depends. When you say you entered illegally 4 times, were you caught all 4 times? Were you given a permanent bar based on these entries? Because you still have to be eligible for adjustment of status. This really just fixes the latest illegal entry. So it depends on whether or not you were caught or you were given a permanent bar based on those entries. So I would need to know a little bit more information uh, to really determine that, because this is just for people who have entered illegally to fix that requirement of having entered legally. So it doesn't get rid of the other ineligibility factors. So if there's a permanent bar based on multiple entries, if it's the 3 or 10-year bar, those those things are still important, and they will run a background check on you when you apply for this. So it really depends on if USCIS knows about all of those entries, or CBP technically. From what you just said, if the next president decides to cancel PIP, this will be the end of it. So I hate to give an uncertain answer, but we're not really sure. Because this is an executive order, if they cancel it, then yes, that could be the end of it, but that also depends on if, like in the case of DACA, there's a lawsuit against that. If somebody files a lawsuit saying that, well, this was legal when I applied, I should be able to get this relief. It depends on a lot of factors. Unfortunately, we'll just kind of have to see how that plays out. This is also a very important reason to vote in November. I know people who are permanent residents or non citizens cannot vote, but for your citizen spouse, make sure they vote this November. I cannot stress this enough. I don't want to sound preachy, but honestly, this is very important. Making sure that programs like this stay in place, that's a reason to vote in the upcoming election this November. So make sure that all of your friends that are citizens, your spouse, any family members, make sure to tell them to vote because it could very well be the end of it. Unfortunately, this is one of those wait and see. We'll have to wait and see what happens. So that's why I'm saying, if you can go ahead and apply now, gather all of your evidence, do so, because we don't know for certain how long this is going to last. While I really hope and pray that it's here to stay, I can't guarantee that. And USCIS can't either. So again, that's just another reason to make sure that people vote in this election. Okay. Question received via text. What kinds of information do I need to provide? So, you need to provide evidence of your marriage. So, that would be your marriage certificate. And if you've been divorced in the past, I would also provide evidence that those marriages were legally terminated. And then you need to provide evidence that your spouse is a US citizen. So that would be a birth certificate from the United States, or it could be a passport from the United States, or a naturalization certificate showing that the person naturalized into citizenship. So those are the most important things. And then it comes to the physical presence. That's what I discussed earlier with either, tax returns, or if you have bank statements showing that you've had a bank account and have been living here, lease agreements, things like different bills that are in your names, something to show that you have been physically present. And then also provide different identity documents. So if you have a valid passport, uh, provide the data page of that, and then your birth certificate. And then they will take biometrics. As soon as you apply, you'll be called to take biometrics. Um, So they haven't said if you should provide a photograph, but I would provide the 2-inch by 2-inch photographs. It is uploaded online, and they even have a really cool tool on, I think it's uh, the DHS website, I believe, that even helps you take a photograph and make sure that it's eligible, that it's a 2-inch by 2-inch one. So then you can upload that JPEG onto your online account. And then the filing fee is $580. Again, you'll pay that online with a debit or credit card, or you can do it by bank transfer, I believe, because it's through pay.gov. Um, I believe that answers that. Also, on kind of going back into the personal uh, opinion territory, I think that if you can show something that works in your favor to make sure that the USCIS officers exercise their discretion, because this is discretionary. If there's anything that would make it beneficial for keeping you in the United States, I would provide that as well. Whether it be, that you're taking care of a sick family member, whether that's your US citizen spouse or children, something showing, or your own medical condition showing that you need to stay here for treatment. uh, Provide like a hardship letter stating what your spouse has gone through during this time of you not having a status, and what it would mean to them to keep you here, what types of hardships they would go through if you had to be sent back. Um, Anything that can really work in your favor when it comes to the discretionary aspect of this, I think would be very beneficial to provide. Affidavits from friends or family members stating good moral character, that they know of your relationship. If you can even provide evidence of your relationship, then just to really make sure that they understand that this is a legitimate marriage, I think that that would be beneficial as well. Anything that will work in your favor when it comes to discretion. So I think that that would be very important to provide as well. Okay. Oh, the next question was, oh, wait, no, sorry. Hmm. Okay. If my PIP is pending and the new president is elected, what will happen to if the new president cancels the program and my PIP has not been adjudicated? So, again, a very good question. And uh, so they will likely adjudicate it. However, that's another reason that you need to get your applications in. I know I keep saying that, but it's the truth, because this is an uncertain time with a relief that has been ordered by the president. So, yes, if it is still pending, they will likely adjudicate it, but make sure that you get it in, before the next president takes office, which is in January. So, honestly, if you can get it in before they're even elected, I would do that as well. But definitely before January. Mm, will I qualify if I'm in removal proceedings? So, this is kind of twofold. So, yes, you will qualify. However, as I was stating before, that does not guarantee this. Just because you're approved this form does not guarantee that you're actually eligible for adjustment of status. So it kind of depends. So for this specific thing, yes, you can apply while you're in removal proceedings, and it can be approved as long as you submit everything that you need to, and the officer works with their discretion and decides that it should be approved. Then yes, you can still apply and have it approved. However, that does not guarantee that you are going to be granted adjustment of status, because those eligibility requirements are still at play here. You still need to make sure that you're not just qualified based on health related grounds, or on criminal background. Although like I said, they will run a background check for this. And it did say on the USCIS website that if you have a criminal background, it's not going to be approved. And if you have criminal charges pending, it will not be approved, but you could apply again once there's an outcome for your charges. So that's something to keep in mind as well. But to answer the question, yes, you can qualify if you're in removal proceedings. Okay, what is the form used to apply for PIP? The form is I-131F, and it will be completely online. There's not even a version to download on the USCIS website. So you will need to create a USCIS account, and if you're doing this pro se, meaning on your own, then you're eligible for PIP. And the answer to that is no. This is really for people who have entered the country illegally, or what's called EWI, entry without inspection. And I was mentioning that DACA recipients are a prime example of this, because before this type of application was available, there was no great way for a DACA recipient to actually adjust their status. It was a great program that allowed people to work, but it was more like a band-aid, if that makes sense, because it didn't actually fix the problem. So this actually fixes that issue. So if you entered EWI, entry without inspection, you can apply for this and then still adjust your status as long as you meet the other eligibility requirements. So this is really great for DACA recipients, because now they can fix that issue of entering without inspection.
Only for the ones that came in.
Yes, only for the yes, because some DACA recipients didn't come in EWI. But if you're a DACA recipient that came in without inspection, then yes, this is a great way to adjustment, and hopefully naturalization. Okay. I have deferred action under DACA or temporary protected status. Am I eligible to make a request for PIP? Again, as we were just saying, yes, you are eligible as long as you came in EWI, entry without inspection. Same goes for temporary protected status. Temporary protected status is a humanitarian relief that is available for certain people who are from countries like I know Cameroon has it, different countries, or the Ukraine was one where you're eligible to stay and get a work authorization, but sometimes people didn't enter legally. So both of those are very prime examples of who this could work for and benefit. Okay, question received via text. If my US citizen spouse has died, am I still eligible for PIP? So yes, you are still eligible as long as you were married on or before June 17th, 2024. You would be, if you already had an I-130 pending, then it would be converted to an I-360 for a widower. But if you did not already have that pending, then you can file as a widower. So, oh yeah, for as long as you haven't remarried. Yes, as long as that's your most recent marriage.
Mm-hmm.
Then yes, you can apply for PIP. And one thing that I would like to mention, when you're applying for this PIP, you can apply at the same time as the petition. So whether that's an I-130 for a spouse or for the stepchild, but or the I-360 for a widower, you can go ahead and apply for this at the same time as the petition. What you cannot do is apply for this concurrently with the adjustment of status application. So that's the green card application. Now, There are certain benefits to that because, then you get the priority date in. But if you were to ask my opinion, I would say to go ahead and wait and see if you get the parole in place approved and then apply for the petition and the adjustment concurrently. And then another thing, if you're not applying for adjustment right away, which I don't know why you wouldn't, but if there is something that is holding you back from applying right away, you can get an employment authorization based on this parole in place. You would apply under category C11 when you are filling out the employment authorization form, but you do need to have it approved before you can apply for the employment authorization. Next question, will USCIS conduct a background check when reviewing my request? Yes, they will. They will collect your biometrics. They typically schedule the biometrics, especially for online applications. They do it pretty much right away, sometimes even the same day as when you submit the application. So you'll get the appointment notice. You will take some form of identification along with you with that notice, and then go to the location that they have specified on that biometrics notice. They will take your fingerprints and your photograph, and then they will run a background check. So, and as I was mentioning before, they could very well use that when determining if they're going to approve the parole in place. Because again, this is a discretionary application. So if you have a criminal background or if you have criminal charges currently, then that's a very good reason that they could use to deny it. Okay. Can I appeal USCIS denial of my request under PIP? No, you cannot. There is no motion to reopen or appeal for this type of application because it's discretionary, which is unfortunate, but they do allow you to apply again. So if for some reason that is fixable, the application is denied, you can go ahead and put together a stronger application and go ahead and file it again. Now, again, it depends on whether or not it's something that's fixable. Like if you didn't provide enough evidence, or I don't know, something wasn't timely filed, or say they requested for further evidence and you did not get that in on time, then that's when they could deny it, and you could still find a way to fix that if you provide the evidence that they asked for, do everything in a timely manner. But that's again why I said that it is important to make sure that you put together a very solid application with all of the required documentation, because you can't appeal it. So you'll just have to apply again, and who knows how many people will be waiting in line at that point. So okay. Okay. The next question, will I receive, or what will I receive if USCIS approves my request under PIP? You will receive a notice. It's a Form I-797 notice, and it will show that the parole in place was granted. It typically comes.
It comes with the I-94 too.
Oh yeah. So it comes usually on. It's just like a sheet of paper that's like a little bit thicker, and it's like tinted green. It's not like bright green or anything, not like the green card, but it's like tinted green, and it'll come with the I-94 on the bottom of it. So it's just like a regular approval notice, but with the I-94 at the bottom. So if you've ever seen like a non-immigrant approval notice, so like an R1 or something like that, where it has the I-94 on the bottom, it looks like that. Okay. Will I be eligible for a work permit? Yes, as I was stating before, yes, you will be eligible for a work permit based solely on this. If you do apply for adjustment of status right away, then you can apply under category C9. So that's somebody with a pending adjustment of status application. If you want to apply solely on this, then it would be C11. But if you're filing the adjustment of status, I would recommend doing C9. Just honestly, because the application for adjustment of status kind of supersedes any other type of relief in a way. I don't know if that fully makes sense or if it just makes sense to me. But anyway, so C9, that's what I would use if you're applying for adjustment of status at the same time. Oh, something else that I want to say before more questions start coming in. I know that when people hear parole, they think that that could be eligible for travel, but this is not eligible for travel. If you receive this and then exit the country, most likely you're not going to be let back in. This isn't like typically when you're paroled into the country, and it's not advanced parole. It's different. This is just fixing so that you don't have to leave the country. So if you're granted this, don't leave the country expecting to come back in like this is an advanced parole or travel document. It's not. This is separate. This is fixing it so that you don't have to go out of the country to apply for adjustment of status. So definitely. How are calls able to come in? Okay. I'm sorry. Unfortunately, using a phone to do this means that sometimes calls come through. And even though we have a focus in place, it's an iPhone, it doesn't seem to block out all of the calls. If anybody has a fix for this, put it in the comments. I'd love to hear that because it's frustrating. And then something else that I wanted to mention is that USCIS has announced that this will be released for 3 years typically. So what that means is it'll be eligible for adjustment of status the day that it's approved, and it will last 3 years. So what that means is that you really need to apply for adjustment of status, again, in my opinion, right away, because I mean, unless there's something really stopping you, then I would go ahead and apply right away, because once that 3 years is over, if you have not applied for adjustment of status, then you go back to whatever status you had prior to this. So based on the type of application this is, that means that it's likely, well, it is no status. So really make sure that you apply, like watch that deadline. If you're not applying right away, really be sure to watch that deadline and make sure that you apply before the end of those 3 years, because you don't want to do something to fix your status and then not actually fix your status. Okay, I'm okay. Okay. Sorry. Another phone call. I was saying, okay, it's granted for 3 years. So if the relief is even still available, then if the 3 years expires, then you could apply again. But I mean, don't waste your money. Just go ahead and apply for adjustment of status right away. And then something else that I wanted to mention is that it is important to note that if you do have any other eligibility factors, that if you need a waiver, to go ahead and file that as well, because this is not a fix for every type of eligibility factor. It's only for people who entered without inspection and are already married to U.S. citizens on or before June 17th, 2024, and who have been, residing in the United States. So if you have some other eligibility, uh, some sort of inadmissibility, uh, you really need to make sure that you're applying for the waiver as well, and not just applying for the adjustment of status, because you still need to fix whatever else could render you inadmissible. So again, whether that's a health ground, criminal, I'm blanking, but any other type of inadmissibility, then you would need to go ahead and apply for the waiver. So that's Form I-601. God, it froze like that. sorry. Again, a phone call. I'm sorry. I'm gonna take a sip of water. Oh my God. Oh.
Yeah, I think that's the end of the question.
Okay. So today we are discussing the parole in place. We do this podcast every Wednesday at 12 p.m. Central Standard Time. So that's 1 p.m. Eastern Time. It is, I don't remember Pacific, but I know it's 6 p.m. in Nigeria. I know that one. So go ahead and tune in to us every Wednesday. We talk about different topics every week. Typically, Dr. Asekun is the one that handles it. He has 2 hearings at immigration court right now, pretty much. So that's where he had to scurry on off to. But typically, he's the one here that does the podcast. And then go ahead and check us out on our other social media platforms as well. We have Instagram, TikTok, Facebook, X, YouTube. We post some or most of our shorts on YouTube as well, where we discuss a wide range of different topics. We decided to do this. We were working on a series about coming to live and work in the United States, but since this application was officially released to the world on August 19th, we decided that it would be very beneficial to go over this, because this is something that is really going to help a lot of people. It's not even just that it's something that's current or trending. We want to be sure that people understand this relief and how it could benefit, or how it could possibly benefit them. We've also received a lot of questions about people saying, is this, or am I eligible for this? Because there's a lot of misinformation going around out there. There are a lot of posts saying that this is just the green card, get the green card with this form, and that's not true. Or we have people who entered legally calling and saying, hey, I think that this would be right for me, and really it may not be. So it's always wise to go ahead and consult with an immigration attorney, because there are a lot of people out there who spread misinformation or could even be trying to scam you. In fact, that's something that was kind of prevalent on the USCIS website about this specific keeping families together parole in place, because I guess there were a lot of people cropping up saying, hey, I can expedite this for you if you pay me a fee, or, oh, this is the only step you have to take. This is to get the green card. And while it's partially true in some cases, you need to know the full truth before applying for any type of benefit from USCIS. So really be careful with the notarios and the scammers out there, because while an attorney may ask, or will likely ask, for a professional fee, which is the attorney's fees, there is no way to get it expedited. I mean, you can make like a humanitarian appeal, but that's not guaranteed. So there's no fee to expedite it. You shouldn't have to pay just to get the form. In fact, there's not even a way to file it as a paper file. It will be rejected if it's sent as a paper file, and the form isn't even available for release on like a downloadable document like that. So honestly, be careful, because there are a lot of people out there who just want to take advantage and possibly take your money. So make sure to be careful when applying for anything or dealing with anybody that you haven't maybe met in person or been on a video chat with or something, because and check out their credentials, make sure that they are legit, because you don't want to get scammed. We get calls all the time about people who went to a notario who said, "Oh, I can do, this for you," and then they just leave them high and dry you know, when they get into trouble. So really check out who you're working with. So again, I am Kimberly with the Law Office of Olu Asekun. This is our weekly Wednesday podcast, and we will be back next week. We will be finishing up the Coming to Live and Work in the United States series. It will just be open questions, so go ahead and send us your questions. Our phone numbers are 817-883-4495, 817-983-4499. And we actually even have a new one. I should have it written down.
It's not no problem.
No, the newest one, because, yeah, we just got it. Office. Let me see. No. I think I saved it in my work, that phone. I don't think I have it saved on here. No. Okay, I don't think I have it, but I'll post it in the comments. So you can go ahead and start sending us your questions for next week. And thank you so much for joining us. Have a blessed day.